Welcome to this explainer. Today, we're going to objectively demystify President Trump's August 6, 2026 executive actions on birth tourism and birthright citizenship. We're dealing with some pretty complex legal mechanisms here, so we're going to strictly focus on what the texts actually direct, the distinct legal authorities they rely on, and the constraints that could practically limit their effect in the real world. Okay, let's take a quick look at our agenda. First, court rulings and new orders. Second, the citizenship document mechanism. Third, changes from the 2025 policy. Fourth, birth tourism immigration authority. Fifth, the 2020 visa policy baseline. And finally, number 6, knowns, disputes, and unknowns.
All right, Section 1, court rulings and new orders, the constitutional baseline.
To really grasp these August 6 actions, we've got to look at the immediate timeline. Back in January 2025, the administration issued Executive Order 14160, which targeted birthright citizenship. But on June 30, 2026, the Supreme Court decided the case of Trump v. Barbara. In that ruling, the court actually invalidated the 2025 executive order, explicitly preserving the 14th Amendment baseline for kids born on U.S. soil to parents who are unlawfully or temporarily present. This judicial block? Well, that is exactly what prompted the administration to pivot and sign 2 distinct new executive actions just weeks later on August 6th.
Moving on to Section 2, the citizenship document mechanism, or withholding federal recognition.
So, in the first order, titled Continuing to Protect the Meaning and Value of American Citizenship, the core bureaucratic mechanism at play isn't actively revoking a citizenship status. Rather, it's withholding federal document recognition. Think of it like refusing to issue a passport. And this mechanism is triggered only when a very strict threshold requirement is met. Neither parent can be a U.S. citizen. If even one parent is a U.S. citizen, this order simply doesn't apply.
Now, if that threshold is met, meaning neither parent is a citizen, the order directs agencies to refuse citizenship documents only if one of 4 highly specific hierarchical conditions apply. Let's break those down. First, if either parent is an alien enemy or a designated terrorist. Second, it applies if either parent is a foreign government employee or possesses certain international organization immunity. Third, and this is crucial, if the parents engaged in a commercial transaction or fraud to access citizenship, which explicitly includes commercial surrogacy arrangements right here in the U.S. And finally, number 4, if the birth occurs in a U.S. territory where citizenship is not conferred by federal statute. Currently, that implicates American Samoa. Up next, Section 3, changes from the 2025 policy, shifting the strategic approach. There is a really notable strategic shift here from the administration's 2025 maximalist approach. By putting the 2 orders side by side, the pivot becomes super clear. That invalidated 2025 order relied on a really broad test. It targeted mothers in an unauthorized or temporary immigration status, combined with fathers who were not citizens or lawful permanent residents. But following that Supreme Court defeat, the 2026 test is much narrower. It requires that neither parent is a citizen, plus one of those 4 highly specific conditions we just went over. The administration essentially designed this new structure to test the absolute outer limits of historically recognized constitutional exceptions. Section 4, birth tourism, immigration authority, and delegating border enforcement. Unlike the citizenship document order we just analyzed, which bumps right up against the 14th Amendment, this birth tourism directive relies on broad, well-established statutory authority. Specifically, it delegates presidential authority under Section 215A of the Immigration and Nationality Act. Because the executive branch already has vast established authority over border admissibility, this specific order functions primarily as an immigration and border enforcement action, not a constitutional reinterpretation. To actually enforce this, the text explicitly defines the target. It defines birth tourism as travel to the United States on a non-immigrant visa for the purpose of giving birth on American soil. And importantly, it also brings any efforts or entities that facilitate such entry directly into its regulatory scope. Now, a completely crucial point of analysis here is separating what agencies are explicitly mandated to do from the discretionary tools they simply may use. The order directs that agencies shall take actions and update guidance. However, it lists actions that agencies may include, things like preventing entry, revoking visas, issuing permanent bars, or executing removals. As of right now, we can't just assume these optional discretionary measures are being fully or aggressively implemented by border agents in the field yet. Moving to Section 5, the 2020 visa policy baseline,
existing immigration restrictions. You see, restricting birth tourism isn't entirely new. Since the State Department update that went into effect on January 24th, 2020, consular officers overseas have already been formally instructed to deny B non-immigrant visitor visas if they determine the primary purpose of the applicant's travel is obtaining U.S. citizenship for a child. So what's actually new here? Well, the 2026 order signals a potential escalation. It authorizes measures that expand the perimeter of enforcement. Instead of just relying on overseas consulates denying visas during the application phase, this new statutory delegation authorizes measures that could restrict physical entry, revoke existing visas, and pursue removals directly at ports of entry right at the U.S. border. Finally, Section 6. Knowns, disputes, and unknowns. Navigating legal friction.
Breaking down the current landscape, we can clearly categorize things. We have confirmed facts. Both orders are indeed signed, and agencies are mandated to issue public guidance within 30 days. Then, we have disputed claims. The administration officially claims these new exclusions match historical Supreme Court-recognized exceptions to citizenship. Conversely, civil rights and immigration groups heavily dispute this constitutional theory, arguing it's just an end run around the 14th Amendment. And this leaves us with some major unknowns: internal agency preparation, the actual intensity of field enforcement, and, of course, most importantly, future court outcomes.
And this brings us to an incredibly important takeaway. Listen closely. It is absolutely essential to state that birthright citizenship has not been legally ended or altered by executive decree. The Supreme Court's constitutional baseline from the June 30 Trump v. Birthright decision remains strictly in place. What the administration has actually created is an administrative friction point, a document denial mechanism that is immediately headed for intense legal scrutiny. The exact legal and operational reality? It's going to remain unknown until we see three critical next steps unfold. First, the Departments of State and Homeland Security absolutely must publish the required public guidance within that 30-day window. Second, we're waiting for official indexing and publication of these orders in the Federal Register. And third, we're closely watching the federal court dockets for civil complaints and motions for emergency temporary restraining orders from critics who are seeking to block implementation. Which leaves us with a pretty provocative final scenario regarding how the judicial system will navigate all of this. Because the citizenship document order strictly implicates constitutional jurisprudence, while the birth tourism order relies on broad statutory immigration authority, is it possible the federal courts will bifurcate their rulings? Could they block the document withholding conditions while simultaneously allowing the border entry restrictions to move forward? That is definitely the question to watch in the coming weeks. Thanks so much for joining this explainer.